The network made an unparalleled contribution to quality, diversity, and equity by hosting guest talks with judges from the Supreme Court of Ukraine during the Russia-Ukraine War, as well as the Supreme Constitutional Court of Palestine and Supreme Court of Israel during the peak of the Middle East crisis. 70% of participants during Global South Network activities since its launch in March 2023 were women. We demonstrate the Global South is not a passive recipient of ideas but an active contributor shaping global norms. Today we are privileged to host Honourable Justice Michail Pikramenos, President of the Hellenic Council of State, Supreme Administrative Court of Greece.
I don't like the long presentations and the long speeches. Dialogue is better than monologue. The case law of the Court of Justice, the European Union and the Strasbourg Court has been instrumental in modernizing national approach to important issues in the field of rights. There is a violation of the European law. The Special Supreme Court, our court, was wrong, in very simple words. Public trust in the European judiciary varies significantly from country to country. However, the level of trust cannot be viewed as distinct from the general differences between high trust societies, mainly in the northwest of Europe, and low trust societies, mainly in the south and east. Historical, social, and economic reasons account for these differences. Trust is the bedrock of any successful operation, whether it be private or state. Judiciary is not in competition with other branches of power, but it is fundamental that trust established and there is a recognition of its independence in the way of its function.
Deseo expresar mi sincero agradecimiento al Dr. Naumen Riaet, la conferencia dada por el magistrado Michail Pikramenos, presidente del Consejo de Estado Helénico de Grecia.
Dr. Naumen Riaet, the founder and convener of the Global South Network, his visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riaet's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism. In these days of backsliding of the rule of law, rising authoritarianism and polarization, it is of utmost importance to strengthen mutual understanding and trust.
Despite the fact that Russian armed forces have been near Kiev, the Cassation Court did not stop its operation concerning judicial proceedings and continued its work. Despite the Russian invasion and air alarms, other horrible things of war in all our Ukrainian regions. To express my appreciation for your assistance, for your help in our fight against unjustified war.
Supreme Courts are sovereign. We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
great initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperation. Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
It's my great honor to invite our guest speaker, Honourable Justice Michail Pikramenos, the President of the Hellenic Council of State of Greece, to deliver his lecture titled The Hellenic Council of State and its Position in the European Legal Order. Justice Pikramenos, the floor is yours.
Thank you very much. I would like to thank you for your invitation. It's an honor for me to speak about a very important issue. I would like also to thank Kari, the President of the Supreme Administrative Court of Finland. He's a very good friend, and we have a cooperation, close cooperation in ACA. Thanks a lot, Honourable Justice Smokovic. I had the opportunity to meet him in Helsinki. Thank you very much, Honourable Justice Mahubebeti Molemela. I hope that we shall have a very interesting discussion. Thank you also, Yves, Gounin, Conseiller d'État in France. He's a very good friend also, and we have a cooperation in ACA. Thank you also all the other colleagues who attend this session. The title of my presentation is the Hellenic Council of State and its position in the European legal order. I don't like the long presentations and the long speeches. It's very boring for the audience. So I will give you some ideas, some points, the basic points, and I think it's useful to have a dialogue. Dialogue is better than monologue. First, some elements for the Greek constitution. The constitution states that courts are to be divided into administrative, civil and criminal courts, organized on the basis of special laws. The Council of State and the ordinary administrative courts examine administrative disputes as the law specifies. Especially the Council of State has jurisdiction, among other things, which includes the annulment upon petition of enforceable acts of the administrative authorities and the appeals for the final judgments of ordinary administrative courts. The ordinary administrative courts have jurisdiction in substantive administrative disputes where the legislator reserves them for the Council of State, and categories of cases that come under the Council of State's jurisdiction for annulment. In the Constitution, we have three principles. The first is the principle of publicity, which covers both the hearing and publication of the judgment. The second principle is the principle of specific reasoning of judgments. And the third is the principle of mandatory publication of any dissenting opinion. Now, second point. The constitutional provisions for the integration of the country in Europe. The Article 28 of the Constitution provides the international convention as of the time they are ratified by statute and become operative according to their respective conditions, shall be integral part of domestic Greek law and shall prevail over any contrary provision of the law. There is also an interpretative clause in Article 28 that constitutes the foundation for the participation of the country in the European integration process. So, the Greek courts must proprio motu examine whether the provisions of domestic legislation are in conformity with the European law and interpret them in accordance with that. This is a main point for our courts. Third point, the influence of the Council of Europe and European Union in the judicial system in Greece. There are two levels. First, we shall tell some basic things about this influence for the judicial system. We have institutions of Council of Europe and European Union, and we have European initiatives and actions entail documents being drafted and prepared by special working groups on justice, which are then sent to the states to be taken into account in devising their own policies. One document of particular importance for the justice sector is the Magna Carta of European Judges, adopted by the General Assembly of the Consultative Council of European Judges, CCJE. The Magna Carta of Judges proclaims that the judiciary is one of the three branches of power in any democratic state. The document consists of 6 key sections covering the entire career of a judge, setting out the basic ways citizens can access justice and the need for transparency in the work of the courts. In Opinion 7 of 2.5 on Justice and Society, the CCJE highlighted the relationship between democracy and citizens receiving information on the organization of public authorities and the conditions in which the laws are drafted. In that broader context, it also included the importance of citizens knowing how judicial institutions function. The CCJE then went on to proclaim the need for courts to have procedures to provide citizens with information about their activities, to facilitate, among other things, the right of access to justice, such as periodic reports, service guidelines, web services, public information services. A critical role has been played in these developments in recent decades by the European Commission for the Efficiency of Justice, CEPEJ, which has published documents on the organization and efficiency of justice and has developed a strong network of experts from all member states of the Council of Europe and from European and non-European countries wishing to improve how their court system operates. In recent years, the EU has focused its attention on how the way in which court systems in its member states are organized and run interacts with the level of economic and social development in those countries. To that end, it has begun publishing an annual report entitled the EU's Justice Scoreboard, which includes data on the performance of member state court. As you understand, all those activities have a very strong influence in the judicial system in Greece. For example, judicial maps. For example, management of the courts for the presidents, for the judges in individual level. Fourth point. The interpretation of the Constitution in the light of the European Union law and the European Convention of Human Rights. The national constitution in modern times does not play an autonomous role and is not the sole protagonist in shaping the social, economic, and political life of the countries of Europe. Membership of the European Union and the Council of Europe has decisive influence on national legal orders and obliges the courts of the member states, especially the highest courts, to develop methods and techniques for interpreting the Constitution in the light of the treaties of the European Union and the Rome Convention. The combined interpretation of national constitutional rules and European rules has advantages and disadvantages. If we compare advantages and disadvantages, the balance, according to my view, is the favor of the advantages. This is because the case law of the Court of Justice of the European Union and the Strasbourg Court has been instrumental in modernizing the national approach to important issues in the field of rights, especially in the field of rights. I will give you 3 examples from the Greek jurisprudence. First, the Article 14, paragraph 9 of the Constitution has absolute prohibition for the owners, partners, shareholders, or managing director of an information media to be in the same time owner, partner, major shareholder, managing director of an enterprise that undertakes towards the public administration or towards a legal entity of the wider public sector to perform works or to supply goods or services. Absolute prohibition for these owners. The Grand Chamber of the Court of European Union, in case C-213 of 2007, held that we have to interpret our constitution under the light of the community law. So the court held that there is a violation of the European law to have an absolute prohibition for the activities of these persons. And after that judgment, the Council of State proceeded to a new interpretation of this absolute prohibition, this constitutional provision, in the light of EU law, and held that the prohibition is not absolute despite the letter of the provision, but relative. Second example, in the case of Likourezos versus Greece, the European Court of Human Rights held that by considering the applicant's election under the new Article 57 of the Constitution, without taking into account that he had been, the applicant, elected in 2000 in full accordance with the law, the special Supreme Court, our court, was wrong, in very simple words, because this situation creates a violation of the Article 3 of the protocol, because there is an absolute prohibition for the persons who want to be members of the parliament and they work in the same time as lawyers. And the problem was that the constitution didn't have a period, a transition for this new article in the Greek constitution. So there has been a violation of the provision of the protocol. Third example from the Court of Luxembourg. According to the Greek constitution, there are absolute prohibitions for the duration of private law employment relationships in the public administration. According to the letter of the constitution, conversion by legislation of staff covered by the first section to permanent civil servants or conversion of their contracts into contracts of indefinite duration is prohibited. Another absolute prohibition in the field of working in public administration. So the contract cannot transform for indefinite duration. We have all, in this case, a judgment from the Court of Luxembourg, and says that this constitutional provision is a violation of the EU law because we have an absolute prohibition for this transformation. 3 examples for the relation between the national constitution and the EU law and the Rome Convention. 5th point, the national legislature and the Council of State under the beneficial influence of the case law of the Convention of Rome. A review of the relationship between the case law of the Council of State and the European Court of Human Rights would lead to the observation that from 1953, the year in which the Convention entered the Greek legal order, until approximately 90s, the Greek court always considered that the right guaranteed by the Rome Convention was of lesser or equal with the right guaranteed by the Greek constitution. And in contrast to the extremely fruitful exercise of judicial power by the Council of State in substantive administrative law from 1929 until 70s, and the particularly creative interpretation of constitution provisions under the Constitution of 1975. Second point, trial. What is trial? Is the institution by which the application of the rules of law in social life is ensured and consists of a set of legally regulated actions by judicial bodies and parties which aim at an authentic diagnosis of the true legal situation. The trial serves several levels. The first purpose of the trial is to protect the rights of any subject of law who is impeded in the exercise of his right. The next objective is legal certainty, which operates at two levels: at the level of the specific dispute with its final resolution. At the second level, the existence of litigation as an institution consolidates society's confidence in the application of the rules of law and enhances the sense of security experienced by citizens within the legal order. According to of Strasbourg, the core of the right of access consists in submitting a claim to a court which has jurisdiction and competence to examine its legal and factual basis and to reach a binding decision disposing of the dispute. So, in this area, in the area of access to the court, we have also the beneficial influence of the Convention of the Court of Strasbourg. And there are some examples, and I don't want to give you details what examples are, what make us change our view for the access to the court. Another very important element of Strasbourg Convention is the reasonable duration of proceedings. We have a series of condemnations about violated this special right, underlining the importance that the Convention attaches to the general principle of the proper administration of justice without delays that undermine its effectiveness and credibility and ultimately lead to phenomena of denial of justice. To this end, the Convention has ruled that states must organize their judicial system in order to achieve the major objective of administering justice with a reasonable time. The issue of the violation of the right to a reasonable length of trial has been addressed by the Convention in a number of Greek cases, and a large number of convictions have been issued finding excessive length of trial. This problem occurred with particular intensity in administrative justice, but it also exists in civil and criminal justice. The Strasbourg Court launched a pilot judgment procedure starting with an administrative trial with the judgment in Athanasiou versus Greeks. The court noted in that judgment that significant and recurrent delays in the administration of justice are a particularly worrying phenomenon which may be of particular concern to the court. Following the above-mentioned judgment, the Greek state enacted the provisions of a law which introduced as a new remedy the application for just satisfaction for exceeding the reasonable duration of administrative proceedings which is brought by each party and is directed against the Greek state. Court of Strasbourg examined in the case Techniki Olympiaki versus Greece judgment the effectiveness of the action for damages within the meaning of Article 35. In general terms, the court held that the system is effective. There are safeguards for the effectiveness of the system. I will finish this short presentation saying that the European Network of Councils for the Judiciary in the report 2017-2018 Public Confidence and the Image of Justice notes that public confidence is vital for the independence of the nation's judiciary. According to the report, public trust in the European judiciaries varies significantly from country to country. However, the level of trust cannot be viewed as distinct from the general differences between high trust societies, mainly in the northwest of Europe, and low trust societies, mainly in the south and east. Historical, social, and economic reasons account for these differences. Trust is the bedrock of any successful operation, whether it be private or state. The judiciary is not in competition with other branches of power, but it is fundamental that trust is established and there is a recognition of its independence in the way of it functions. Some first conclusions. There are always judgments from both the European countries that they give us the opportunity to modernize our state, to modernize our courts and judicial system. We earn a lot. It's very difficult to have very fast results. But I think that we have the opportunity to improve our state, to improve our judiciary. I think that the European principles, the European laws, the European principles and the European Charter of Magna Carta, and all the work of the experts in Europe is very useful for us, and we have to work as legislator, because in many cases we need the legislator, but also in good practices. I believe that the rules, the law, is the beginning, but the most important is the implementation of the law. And I think that this is a very difficult field, how to implement laws that they want to change the views of people who live with stereotypes and with traditional attitudes. Thank you.